So where I'm going now?
Home. You get a sign?
Yes, indeed. Oh, I want a 3 Malcolm shot.
I'm really here. Is actually given a chance to live a life I have been denied.
Over 3,000 exonerations have been granted since 1989 for people that were wrongfully convicted. This is the case of Malcolm Alexander, who has spent 38 years in prison for a crime he did not commit. How was that possible? Let's dive in and see what happened. On November 8, 1979, at around 11:30 a.m., a black man entered a recently opened antique shop in Gretna, Louisiana. The 39-year-old white female owner, B.N., started to feel uneasy. He grabbed her from behind and hit her in the head with a revolver as she approached the front door in an effort to divert him to outdoor furnishings. Then, while holding a gun to her head, he raped her in a bathroom at the back of the store. He assaulted her and then walked her to the phone that had been ringing all during the event. B.N. finished the call without alerting the caller while he had her in a chokehold and threatened to shoot her. The perpetrator then compelled her to enter the restroom once more and raped her again. She was told not to move and the man ran away. B.N. called the police while cleaning herself with a towel. 3 hairs were discovered by the police on the bathroom floor, and they also took the towel as evidence. B.N. described the attacker to be a black man with medium complexion in his early 20s, 6 feet tall, weighing between 165 to 170 pounds. He was reportedly wearing a pair of blue pants, a dark windbreaker, and a navy watch cap. The female claimed that he arrived at the shop riding a 10-speed dark orange English racing bike. Police released the description, and 10 minutes later they stopped a black male riding an orange 10-speed bicycle with his pants unzipped. The man was brought outside of the antique shop as B.N. stood inside and looked out the front window at him. She claimed that that man wasn't her assailant. The woman was taken to the hospital for medical care, and there a rape kit was taken. A few days later, on November 30th, 1979, B.N. spotted a man who she believed could be her assailant. When the police looked into him, they discovered that he was employed at the car business Superior Pontiac. His co-workers described him as being a very hard-working man that could never engage in sexual assault. Police presented a photographic lineup which featured the man from Superior Pontiac to B.N. on December 18, 1979, but she was unable to identify anyone as her assailant. 2 months later, in February 1980, Malcolm Alexander, then 20 years old, was detained by the police because a woman accused him of allegedly assaulting her. Alexander, a black male, told the police that this encounter was actually consensual and that it happened only after he handed the woman money for it. Despite being only 5 feet 9 inches tall, a detective thought that Alexander might be exactly the person that attacked B.N., even if he was not charged on the accusation for which he was originally brought in. On March 24, 1980, Detective O'Neill Denew Jr. of the Jefferson Parish Sheriff's Department requested that B.N. view a different lineup of photographs that featured Alexander. According to Denew, B.N. recognized Alexander, although her recognition was just tentative. On March 27, 3 days later, B.N. watched a live lineup that featured Alexander. He was the only person in both lineups, which is considered improper and suggestive since someone can unconsciously associate someone that was saw in the first lineup with the crime that they were accused of committing. Detective Mark Nuzzolillo ran the lineup because Detective Denew was in court and could not be there. In his report, Nuzzolillo crossed out possible and typed tentative next to it. Denew conducted a private interview with B.N. after returning from court 3 hours after the lineup. He said that B.N. was now over 98% certain that Alexander was her attacker when he reappeared. Alexander was taken into custody and accused of aggravated rape. On November 5, 1980, he was put on trial. The entire trial took place over the course of a day, from jury selection until the verdict that Alexander was guilty. The trial's transcript was barely 87 pages long, and Joseph Tosh, his attorney, did very little to defend him. It wasn't the first time in which Tosh let his clients down, though. In 1999, he actually lost his license due to more than 50 instances in which he accepted fees, accomplished next to nothing or actually nothing at all, and refused to return the money. No forensic testing were carried out despite the presence of a rape kit, a towel that contained genetic material, and 3 hairs discovered on the floor where BN was raped. Neither the defense nor the prosecution asked for any testing of evidence. The New informed the jury that BN without hesitation identified the photograph of Malcolm Alexander as the guy who performed the rape on her, despite the fact that his report on the March 24, 1980 photographic lineup said that BN's identification of Alexander was tentative. Detective Nuzolilo, who oversaw the lineup on the 27th of March 1980 and completed the report with designations possible and tentative, just stated in court that BN recognized Alexander. On cross-examination, Alexander's attorney didn't bring up those descriptions at all. Years later, Alexander's attorneys would not be able to ascertain whether the prosecution concealed the reports describing the identifications as tentative or if Alexander's lawyer had the reports but was so inept that he failed to understand their importance. Alexander was named as BN's attacker during her testimony. Once more, it was not mentioned at all that her identification was just tentative. Alexander, who was employed steadily by a contractor at the time of the rape, was not represented by any of the defense witnesses. Tosh, his lawyer, never even looked at the possibility of him having an alibi. Tosh didn't address the jury in his opening statement, and the trial record only contains 4 pages of his closing remarks. At 5:20 p.m., the jury was led outside to deliberate. They had already decided to convict Alexander at 6:16 p.m., returned to make the announcement, and were then dismissed. Just 56 minutes later, the judge gave Alexander a life sentence without the possibility of parole. Alexander and his family were persuaded by Tosh that they should appeal, but Tosh never did submit the appeal. After learning that Tosh did not do anything in this situation, the family decided to turn to another attorney. Though the appeal filing time had passed, that attorney was still permitted to do so. The Louisiana Court of Appeal, however, rejected it. After reading a news article on DNA testing in 1996, Alexander contacted the New York-based Innocence Project for assistance. The physical evidence was never found, however, as court authorities informed the Innocence Project that it was accidentally destroyed in 1984 when several hundred boxes of evidence from closed cases were mass dismantled. The destruction was attributed to human mistake which should not have happened by a deputy clerk. The Innocence Project ended the investigation, but Alexander did not. He submitted a motion for testing after, in 2004, Louisiana passed a law required post-conviction DNA testing in the hopes that it would prompt more investigations for evidence. Additionally, he submitted a federal writ of habeas corpus petition. His efforts paid out in 2013 when the hairs that were recovered from the bathroom floor where BN was raped were found in the crime lab of the Jefferson Parish Sheriff's Department. Innocence Project and the prosecution agreed in 2015 to test the hairs for DNA, and the procedure was carried out in 2016. According to the testing, all 3 originated from the same person. Alexander was disqualified as the hair's originator. Innocence Project submitted a request in 2017 asking for the conviction of Alexander to be overturned. They cited DNA evidence as well as the ineffectiveness of Alexander's trial defense lawyer. The petition stated, "The most logical conclusion is that the hairs originate from the man who repeatedly sexually assaulted BN from behind on the floor in the same spot where these hairs were collected." The conviction of Alexander was overturned on January 30, 2018. After nearly 38 years in jail, Alexander was released after the charge was dropped by Judge June Barry Derensburg. Barry Scheck and Vanessa Potkin of the Innocence Project expressed gratitude to the prosecution and the Jefferson Parish Sheriff's Office. Scheck noted that the District Attorney's Office and the Sheriff's Office were quite cooperative in trying to see what transpired. After a thorough investigation over the past 2.5 years, I agree with Mr. Alexander's post-conviction attorneys that the defense attorney during the day-long trial 37 years ago provided ineffective representation in violation of his constitutional rights, said Orleans Parish District Attorney Paul Koenig Jr. Alexander didn't leave jail unaccompanied. He reunited with the puppy he had reared while imprisoned a day after being let free. Innocent, or simply In, was the name of the 9-month-old puppy. I named her In because I was innocent and she was innocent, Alexander told a CBS affiliate. On April 22, 2016, according to Alexander, In was born. He admitted to Today, I wrote the date on my heart. I can remember her birthday better than I can remember my own. In spite of the fact that there are more and more programs allowing offenders to train and nurture dogs, In and her mother weren't part of one. They were companions and pets which certain prisoners are allowed to retain. She was the runt of a litter of 10, according to Alexander. He picked her because he believed she was the one who required his love the most. He remembers telling In back then, one day we'll be out of here. Just be patient. In resided at Alexander's fabrication facilities, the metal and wood shops, during the interim period leading up to their release. There, he fed her and took care of her. Having a dog is a privilege, declared Alexander. It makes the world different. His mother and sister, his son and his grandson, both named Malcolm, all awaited Alexander. Alexander submitted a claim for compensation from the state of Louisiana in May 2019. A ruling in Alexander's favor from the Louisiana Fifth Circuit Court of Appeal would entitle him to $400,000, $40,000 for each year of wrongful imprisonment, capped at 10 years, according to Alexander's attorney, Zachary Crawford. Personally, I feel like $400,000 is not nearly enough to compensate an entire life behind bars. The system definitely failed him. He spent more time in prison than outside of it at the time of his release. He was basically robbed of his life. But yeah, that's all for today, guys. Please let me know in the comment section what do you guys think about the case. Please hit that like button and subscribe to my channel if you liked the video. I will post more videos like this because the harsh reality is that it happens way more than we would like to believe it does. For now, go watch the video on the screen right now to learn what were the last words of all the women executed by the US. See you next time. Bye bye.